Thank you.
Thank you. Good morning, everyone. How's everyone doing? Good? 9 a.m. on a Saturday.
We're doing good.
Well, we got 9 a.m. on a Saturday in a different time zone for a lot of you, so thank you all. Katie, Virtual, wonderful job. Alex, thank you for organizing such a great conference. My talk builds on almost perfectly Virtual's paper. I think, was it intentional? Did you set it up?
Yeah, I set it up. I actually wrote it this past week once I learned about what you're doing.
Set this up. So what if I were to tell you that over the last 20 years there's been a monumental shift in how courts have approached the rational basis test? Okay? And I'm not just talking about the rational basis with bite that Bertrand mentioned, you know, the Cleburne, Moreno, Romer standard. I think there's something going on that's a little bit deeper. This is a conventional narrative, so let me offer a different narrative. What's going on is a wholesale change in the way we've been taught common law, in the way we teach common law. Okay? Equal protection jurisprudence is not really anymore grounded in suspect or quasi-suspect classes. They stopped recognizing those a long time ago. There's almost no discussion of fundamental rights. If you look at recent opinion, which I'll walk you through, there just isn't discussion of that. And perhaps most strikingly, federalism plays into it, but this is not the federalism we know of. It's a form of reverse federalism, where the states conferring rights, let's call them dignity, upon the people actually influences the federal constitution. And what if I'll tell you that there was one man who did all this by himself? And you know his name. And the evidence isn't only where you expect it, though. It's like Voldemort, he shall not be named. You know, but the evidence is not only where you expect it. It's not just, you know, in Romer, Lawrence, and now Windsor. It's in a lot of cases by that same guy. Kelo, Stop the Beach. Bond, his influence on Heller. In these cases, you see a very constant trend. You eschew the norms of scrutiny. Okay? He never even mentions tiers of scrutiny. Instead, courts have to remain vigilant about singling out certain people. We're not talking about suspect rights or suspect class or fundamental rights. We don't see that language. This frustrates scholars. People say, why is he not doing it? I argue it's actually kind of intentional. So for Justice Kennedy, in case anyone who wasn't sure what I was talking about, this is not some sort of rudderless, super median justice who's cobbling together whatever he feels like. There's been a very deliberate effort to make these changes. And if you go back and you read the last, 25 years of his jurisprudence, you see a very deliberate pattern. And what I find most fascinating is that he and Justice Scalia have done this long cat and mouse game. And you see the same trends over and over again, where Kennedy's making these moves which have to get to 5 votes so people join him, and Scalia's calling him out on it. And there's just been this wholesale change. So these are the 3 kind of moves that I've seen in these cases. So the first one is you kind of eschew the traditional notions of scrutiny, both in terms of suspect classes and fundamental rights. The second move is this merging or conflation of due process and equal protection. So usually due process refers to conduct, right? And equal protection refers to various forms of status, classes. These have been merged. We see this a lot with the same-sex marriage cases, but elsewhere. And the third one is looking to the states through this reverse federalism lens as bulwarks of freedom that actually bolster constitutional rights. And I'm actually not limiting this just to the states of the United States, because international law jurisprudence is much the same. To look to the other countries of the world to inform how rights should be defined versus the American Constitution. People think these are not related, but I had this epiphany when I was reading the Windsor opinion, going, wow, this looks very much like Lawrence. And wow, this looks like Roper v. Simmons. And wow, this looks a lot like Romer. And there are just certain trends. So what I'm going to take you through is kind of a guided tour of maybe 25 years of common law. I don't have nearly enough time to do it. It was a blog post that turned into an essay that turned into an article, and I'm going to try turning from something else. But there's a lot of good stuff here. Okay? But what's interesting, though, is lurking throughout this entire jurisprudence is a fear of Lochner. And at every single step of the game, whenever there's any effort to heighten rational ways of scrutiny, they jump in and say, Williamson v. Lee optical. We're not going to go past that. Everyone from Thurgood Marshall on down, even in opinions where they want to have heightened scrutiny. So while their rights are, with respect to race and other things, the economic liberty is still kind of kept in the backdrop. Okay? So by blending together equal protection and substantive due process, Kennedy's actually evolved how this works. All right? So let me walk you through this in a little bit more difficult, a little bit more detail. traditionally we think of scrutiny in terms of a means and fit, right? Is it narrowly tailored, serves some sort of governmental interest? But under this new rubric, what the court is focusing on more, and so again, Birchall set me up perfectly, is purposes and effects. What was kind of the purpose of passing this law, and what's the effect on the people? I actually argue that in Kennedy's opinions, tailoring no longer matters much. If you look at a case like Romer, right? He basically says it doesn't really matter what the how narrowly tailored this law is, it can never be saved. Same for Lawrence. Same for Windsor. There was this wonderful colloquy in Windsor, which you might remember, between Justice Kagan and Paul Clement. It was a great colloquy, and it exemplifies it perfectly. I'm a huge Kagan fan. And then Kagan goes, Counselor, in the House reports, didn't it say that DOMA was passed because of a moral disapproval of homosexual relations or something like that? And Clement goes, yeah, but if that's our standard, if that's our burden, then we lose. Paul Clement basically conceded that that's the burden. So what we actually see is looking not solely at whether can Congress narrowly tailor it by having these various reasons why they want it, uniformity of federal law. That's no longer enough. The aspect of having any kind of moral disapproval, that's your purpose, that in of itself kills the law. And it's this singling out, and the word Justice Kennedy uses is actually disability. So you can read Romer, and he writes that the amendment, or the Amendment 2 in Colorado, placed a disability on gays and lesbians. If you look at his opinion in Lawrence, he actually spoke about this disability as well, of certain people and relations. And the same thing in Windsor. He says it's a unique disability on couples of this nature. So you see this trend that goes through a lot of his places. And the frustrating aspect of all three of those opinions is that he doesn't actually talk about equal protection or due process. They're very much conflated. It frustrates scholars to no end that he doesn't identify are gays and lesbians a suspect class, or is homosexual sodomy a fundamental right. He never even touches that. Even look at his opinion, or his joint opinion, Planned Parenthood versus Casey, right? Is there any discussion of fundamental rights there? Nope. Does he talk about the right to privacy? Nope. What does he talk about? Liberty. The same liberty he talks about in Casey, he also talks about in Lawrence, which then he talks about in Windsor. It's this notion of certain freedoms. And where is this liberty coming from? Here's the interesting part, the states. So if you look at his opinion in Lawrence, he actually cites the recent history of states repealing sodomy laws as evidence of why we should have this, that all these states, I think it was like 40-something states in the Union, 47, 48 states in the Union, had repealed the sodomy laws. This was actually a conferral of dignity upon the people. And because of this, the federal constitution is respected. In Windsor, he does exactly the same thing. He says, look at all these states, I think there were a dozen of them at the time, that have allowed for the recognition of gay marriage, right? By the states recognizing gay marriage, they've actually conferred these rights to people. And the federal constitution in response should respect this and protect it. It's this almost backwards vision of federalism, because usually it's a top-down thing. The federal constitution informs the states, but here it's the reverse. And even looking at opinion like it's in Roper versus Simmons, about execution, was it the minors or the mentally handicapped, I never remember which one, but he cites international law, saying, look at all these countries that have conferred these rights on people. This should inform our analysis. Okay? I think that the next move that he makes is something that's been ongoing for quite a while, which is this kind of breaking down the distinction between status and conduct. And this might seem like a nice point, but if you think about it, he's actually conflating equal protection due process, right? Due process protects conduct, equal protection refers to status. And if you read his opinion in Lawrence, and let me get the quote, it's a really good quote, and you probably read it, didn't think much of it, but he says, the equality of treatment and the due process right to demand respect for conduct protected by substantive guarantees of liberty are linked. He actually uses the word linked in important respects. And the decision on the latter point advances both interests. So in his mind, there's not much of a difference between status and conduct, between status being gay and conduct being, engaging in, I don't know, gay stuff like getting married or having sex, whatever. There's not a difference for him in this respect. And I think we saw this again in another case that he joined CLS v. Martinez, the Christian Legal Society. And Justice Ginsburg had this with what Admiral Tech called a time bomb, where she said our court doesn't draw a distinction between status and conduct. That being gay and acting gay, if that's such a thing, but these aren't different. So our entire idea of are we protecting people in classes or protecting activity, in Kennedy's mind, doesn't even matter. And you see this in Lawrence and Windsor. And Windsor, again, Justice Scalia is irate, saying, what is this opinion? Is it equal protection or is it due process? And Kennedy it's totally intentional, but he just runs through the entire thing. He describes this as a careful consideration, which considers both aspects of the people's ability to live their lives in a certain manner, but also the ability of people to be gay. It's remarkable when you look at this light. I call this almost a constitutional chimera. I don't know if I'm going to stick with that phrase, but it cobbles together so many different aspects of constitutional law into one single analysis, which at its heart is aimed at preserving the liberty of the individual from the state, both in terms of your status, your conduct, your ability to receive dignity, rights from the state, and then the federal courts are responsible for protecting this. And where I think this matters a lot is it brings coherence to a doctrine that often lacks it, in one very important respect. I don't think this is just about gay rights. This is the big question. Michael Dorff had a blog post shortly after Windsor was decided saying, is this about gay rights? And he was like, no, it's probably not. I think you're going to see this in a lot of other aspects of the jurisprudence. And I mentioned cases like Kelo and Stop the Beach and Bond. For example, if you read Justice Kennedy's concurring opinion in Kelo, he voted the majority to uphold the condemnation. But what he actually said was, if there is an action by the government that singles out certain people, that imposes a disability, there should be form heightened scrutiny. And he cited an opinion of his, it's called Eastern Enterprise versus Apfel, which I doubt anyone was actually ever read, but if you actually read the Apfel opinion, it was actually like a due process case. So he's not only conflating equal protection and substantive due process, he's also bringing the takings clause in. If you read the Stop the Beach opinion, this was a case about judicial takings in Florida, whether the courts in Florida could stop taking a property in the beach. And he actually conflates due process, equal protection, the takings clause, all in one. And then Justice Scalia says, Lochner, 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 you're doing Lochner. But this isn't every one of his opinions. Even if you look at Heller, which of course was a 5-vote block, but there are portions of Heller that don't really make sense. They're not Scalia. There's an entire portion where there might be a form of heightened scrutiny for this, but not for that, sensitive places. And you actually see this kind of language that when certain people are being singled out for differential treatment. I can go on, but if you look at just about any case he's written in the last 25 years, you see these same fingerprints. I'm actually somewhat hesitant about publishing this now because I want to see what happens in the Schuette case. This is the Michigan affirmative action case. It was just argued a couple weeks ago. But it's curious. I'm guessing, I can't make predictions, I'm always wrong, but it's very likely that the court might simply say that this law is not imposing disability. Because now this goes a little bit to what Bertram and Katie were talking about. But in Kennedy's eyes, the law mandates equality rather than inequality. And if you look at his vote in Parents Involved, he views affirmative action as a very narrow thing that should survive by the skin of its teeth. I don't think he views affirmative action in the same lens of the states conferring equality. I think he would actually view the Michigan Amendment as a good thing, that it's moving towards this race neutrality. Like he wants neutrality for the law, where gays and lesbians treated equal, blacks and whites treated equal, but he doesn't want the state to intervene unless it's absolutely necessary. So I have no idea if there's any accuracy, but I encourage you, and a lot of you teach common law, when you go back and read a number of the cases I mentioned, from Moreno to Romer, to Cleburne, to Casey, to Lawrence, to Windsor, Kelo, Heller, I mean there's others I didn't even mention. Look out for these things in Kennedy's flair, his rhetoric. And Laura had a great paper on the rhetoric yesterday. I mentioned this. Look, totally aside, look how he changes his rhetoric from Romer to Lawrence to Windsor. If I'm right, I don't think he used the word homosexual in Windsor. Am I right about that? I'm pretty sure, I don't think he used it, but he did use it in Romer and Lawrence. So just even how his own rhetoric has evolved, which I think is an indication of his own views of how these rights are developing within the literature. So I'm going to stop now because we have a really packed panel here and some really smart people, and I want you to tell me why I'm entirely wrong and why I've missed the boat. Anything else? All right, thank you so much. I think Paul is the first question.
Just raise your hand, John, and then I'll let him break the line.